Good morning, everyone. I'm Miriam Huertas, the Senior Vice President for the Allentown Chamber. We're going to wait just a few more minutes for a few more folks to join us, okay? Hang tight. Okay, good morning, everyone. Thank you again for joining us at the Business Success in a Post-COVID Era. I'm Miriam Huertas, the Senior Vice President for the Allentown Chamber, and I'm really happy that you have chosen to join us for this webinar. I want to start by acknowledging and thanking today's sponsors and presenters, Gross McGinley LLP and ESSA Bank and Trust. So today we have an excellent group of panelists who will bring you the most up-to-date information on the CARES Act, PPP, Paycheck Protection Program, contracts, reopening your business safely, and the new restaurant guidelines. Representing ESSA, you will hear from Barry Reifinger, Jim Ferry, and Aaron Petrulowicz. And from Gross McGinley, we have Thomas Reilly Jr. Esquire, Lawrence Baziel Esquire, and Jason Ulrich Esquire. A few housekeeping items. First, we are recording this session, and we ask all the attendees, audio and video will be off during the presentation. We do want to get your questions answered. So at the bottom of your screen, there's a Q&A section. And if you would put your questions there, we will make sure that we get all your answers to your questions. It's a little different from the chat, so please use the Q&A section, okay? I think it's gonna be a great presentation. And now I'd like to officially begin our webinar with our first presenter, Barry Reifinger, the Senior Commercial Relationship Manager at ESSA Bank and Trust. Barry?
Hello, everyone. I'm going to talk about the Paycheck Protection Program. And to start that off, I want to go a little bit into the background of that program. It's been around now for about 4 months. Our bank has done about 700 of these loans. I've done about 70 of them personally. And anybody that's had them knows it was a little trying process to get started, to get the paperwork together. But now we're going to look into, the forgiveness end of that and what needs to be done to hopefully get the money that you did receive to be entirely forgiven. Just as a background, the original loans were 2-year loans, and they had a maturity of, an interest rate of 1%. The loans are deferred for 6 months. There's no collateral that was taken with the loans, no personal guarantees, and there were no fees charged. The bank documented the loans didn't charge any fees. The government didn't charge any fees. Um, Moving on to the next slide. I don't know if is that something I could do or somebody can move that for me. Okay. There were changes made due to issues that people had with the program. The main issue seemed to be that certain businesses could not get back to work, particularly something like a restaurant, and I know we'll be talking about that later. They were not allowed to physically open, so they could not get their employees back to work. And this was the primary purpose of this program, was to have employees working, have people working. And because of that, the program was adjusted to allow more money go to other expenses such as rent and mortgage and utilities, and a little bit less to the payroll. So that went down from 75% on the payroll to 60%, and then again allowing up to 40% for other expenses. So it's a little more user-friendly now. It also changed the original program from an 8-week program to 24 weeks. And in addition to that, they spread the loan payments out over a 5-year period instead of a 2-year period with the loans that were done after June 5th. And they also revised the application form. We go to the next slide. So now you need to start preparing for forgiveness. You got your money, you hopefully used it as you were supposed to, and now you have to start working on that. So you're going to start gathering some information to provide to the lender that you used initially to ask for forgiveness. There are certain items there that are listed, details on how you use the loan, information on the payroll, documentation on your expenses. And then we moved into how we calculate the forgiveness. It's going to be very similar to what you did initially to determine your payroll. You use the same type of forms. It's very similar with documentation you're going to provide. Initially, you may have given the bank a 941 tax filing, a quarterly tax filing, something like that. So we're going to need information on payroll cost, any interest that you're looking to get reimbursed for, rent and leasing agreements, and utility payments. This is a changing process, just as the original loan process was. A lot of people would call us and ask questions about what was going on, and it was hard to give specific information because the SBA was changing the rules constantly and actually determining what we needed to do. So this forgiveness process seems to be the same, working the same way. Okay, so when you apply for forgiveness, there is an application that you're going to need to complete. It will kind of walk you through what you need to do, the documentation you need to give. As I mentioned before, you're going to need some type of payroll information. I would recommend if you use somebody like ADP that you ask them if they can provide the information that you're going to need to submit to the bank. Because in addition to the application, you're going to need to give us copies of documents that really support everything. You're also going to need information, could be bank statements, whatever, for the mortgage interest expense, lease payments. We may need to get copies of checks, utility bills, all that information that's going to be critical that you do provide to us so that we can submit your request to the SBA for forgiveness. These are some specific forms, as I mentioned, 941, payroll tax reports, anything that you have, quarterly statements, again, ADP or other payroll services that can help you with putting together information, payment receipts, canceled checks. If you're a sole proprietor, you may need a Schedule C of your tax return. Those are the, again, types of things that, and you can work with your lender specifically. They will tell you, if you didn't provide something, what else they need from you. Again, this gets in more specifics on the payroll cost, what you, again, would need to give the bank, certain things that do would qualify. You'll see on this list that, compensation under $100,000 will qualify. You'll also see a little later that the compensation for people that make over 100,000 will not qualify. So I won't go into the specifics here, but you can look at the list there and see everything that we would need there. And as I mentioned, if it's an employee that's outside the U.S., is not going to qualify. Annual wages over 100,000 will not qualify. Employees that are full-time, part-time, could be a paid internship. Those can all qualify as employees for your forgiveness. Okay. And then what will happen is once you submit the information to us, we will take the application and review all the supporting documents that you gave us. If we're satisfied with everything, we will submit it to the SBA. If we need additional information, we will get back to you, let you know that there is additional information needed and specifically what we would need. Once it leaves our hands, goes to the SBA has 90 days to review your information and determine if you do qualify for forgiveness. If some of your loan is not forgiven, the original loans that were done before June 5th have a 2-year payment period. The first 6 months, there's no interest that was due. It's deferred. And then you have basically 18 months of that remaining 2-year term to pay back the principal and interest that was not forgiven. If it was a newer loan that was done over a 5-year term, again, the first 6 months you would have deferred interest, and you would pay back the remaining over the remaining 4.5 years left over. The payments are based on a 1% interest rate. There are no prepayment penalty fees, so that if you would want to pay it off, you can pay it off without any type of fee. And you would start paying back once the SBA would make a determination that you still need to, some of your loan was not forgiven. Okay, and with that, I'd like to turn it over to my ESSA colleague, Jim Ferry, and let him do the next section.
Hey, thank you, Barry. Good morning, everyone. We thought it would be informational for everyone just to give you a brief overview of some of the things that we've done corporately to mitigate some of the issues that we've faced over the last couple of months with the epidemic, the pandemic, and COVID. So just a little bit of background. ESSA is based in Stroudsburg, Pennsylvania. That's where our corporate offices are at. In addition to that facility with backroom support, we also have some regional offices, Wilkes-Barre, in the Lehigh Valley between Bethlehem and Allentown, and the Plymouth meeting. And because we were working in 7 different counties, we adopted a plan early on to kind of address some of these concerns about employee safety and customer safety. So in mid-March, we convened a leadership team, a COVID-19 leadership task force which met twice a day early on to kind of set the groundwork for, the direction the bank was going to take regarding employees and customers. We had daily emails go out to our employee base. We kept our customers informed via our website and social media as far as some of the changes that we're going with limited branch hours, the need for appointments, the additional services that people could use, such as electronic services, mobile banking, night drops, ATMs, and such. We made a practice to be fully communicative to our employees. We had conference calls 3 times a week, just outlining the status of where we were at, trying to take a temperature check for how our customers were reacting to the changes we had put into place. Our bankers, our commercial bankers, our retail bankers were very upfront and forward with our customers, reaching out, asking how their businesses were doing during this difficult time, and really, fielding any questions that they might have had about, the PPP loan program or just banking in general. So we really tried to be proactive in our approach with reaching customers and safeguarding employees. We did, as I mentioned, limit our branch hours in certain locations. We went to a practice for appointment only. If somebody was coming into the lobby that they needed to sign a loan or to open an account or access a safe deposit box, it was by appointment only. We were very diligent about enhanced deep cleaning in our facilities through some enhanced cleaning schedules. We provided all of our employees with masks. We felt it was important that everybody have a standard uniform look, so we designed and provided ESSA Bank and Trust masks for everyone to wear, multiple hand sanitizing stations throughout the locations and such. As part of this initiative, we took our back room support, our support staff, and we have about 150 people that started working remotely from home since the middle of March. And, we have had the infrastructure set up to accommodate that through system access. Anything that we can do at a desk in an office location, our folks can do at home. So we were very proud that we got that turned on very quickly. Within 48 hours, we had our remote access abilities up and running across the company. And we're still in that position right now where our branch in the front line is serving customers in the branches, but the rest of us are at home or in a remote location, working to support the teams remotely. And it's worked out well. We've adopted new technology internally, Microsoft Teams, Zoom meetings such as this, to really, help customers and our employees adapt. Our website's been a really crucial vehicle for us in conjunction with social media to get the word out about the policies and the changes that we've been done on a corporate level. What I'm going to do now is turn it over to Erin Petrulitz, and she's going to talk a little bit about our Allentown location, which is, practically implementing some of these procedures on a daily basis, and it kind of mirrors what goes on across the footprint. So I'm going to turn over now to Erin. So.
Good morning, everyone. Thank you, Jim, for that introduction. As Jim was talking on a corporate level, we're going to actually hone in now and talk a little bit real quickly about what it is that we're implementing here at the branch. We are back to being fully open Monday through Friday, 9 to 5. So a couple of the things that we've been doing here is obviously we've been opening the branch every morning and doing a full disinfectant. Cleaning, deep cleaning, we basically wipe everything down that anyone could have possibly touched. Some of our branches, not necessarily my branch, but some of our branches do have more than 10 employees. So what we're doing in those branches is we are only allowing 5 employees at a time. So some of the branches are rotating throughout their employees. Of course, we are social distancing. We know CDC guidelines state that we still need to continue to do that. So we are stationing our employees to be 6 feet apart. Of course, we're wearing gloves and wearing masks. We are also requiring that our customers are wearing masks. We are actually denying access to the building if they are not wearing a mask. So, we do have signs posted everywhere letting them know that before they even enter the building that they would need to be wearing a mask. Banking is a little bit different. So, most of the time retail stores, customers are walking in with a mask on, which seems normal. But for bankers, wearing a mask walking into an institution can be a little bit threatening for us. So we do have something called a greeter now stationed at our front door. And we are just requiring, within obviously maintaining that 6 feet of social distance, we are asking them to just quickly remove their mask for us so that we can identify who they are. And then obviously put your mask back on, and now you may follow through to your teller. So, and going along those lines, once they're in the building, we do have markers on the floor sectioned out to obviously keep the customers as well 6 feet socially distanced. And then we do have plexiglass up in front of our tellers so that there is a barrier between the teller and the customer. And then we do ask the customers that they follow a single flow of traffic. So everything is a one-way. So they'll come in one way and exit one way. We're not having an interchange of flow there in traffic. And of course, at the end of the day, we are also completely disinfecting the branch. We are wiping everything down. We are making sure that we're sanitizing everything that we possibly can. So we're doing our best in our new environment. So that's really all I have from the branch perspective. So next up, I'm actually going to turn it over to Tom Reilly. He is a senior partner at Gross McGinley, and he is going to be discussing how to safeguard your business.
Okay, I think my audio is on. Is my video now on? Okay, I'm assuming it is. Okay. There we go. Hi, everybody. My name's Tom Reilly, as Aaron said. Before I start with my remarks, let me just share a quick story with you. And it's something that came into my mind early on when the closings began and the world suddenly changed around March 16th. It's a story about the USA Network. Now, you think today as the USA Network is a large cable network, but at one time it was a fledgling local cable network called the Madison Square Garden Sports Network. It only was on the air from 5 o'clock to midnight weekdays and noon to midnight on weekends. Very, very limited startup cable network. When it first was established, it bought old end-of-life equipment from the broadcast networks that it used in its operations, including the backup generator that it needed in case of power failures. Two quick interesting facts about the USA Network. The first cable network founded by a woman who served as the CEO until it was ultimately sold for $16.7 billion. That's right, $1 billion. And secondly, the first cable network to do its transmission over satellite rather than microwaves. And the satellites play an important part of my quick story here because there was a power failure, and the satellite farm went down. The USA Network couldn't beam its signal up to the satellites, which meant the signal couldn't come back down to the various cable systems that carried the network. And that meant the commercials weren't going to run, and that meant the USA Network wasn't going to make money. So one of the senior executives in the sales department hopped in his F-150 pickup truck, drove out to the satellite farm, and in a very dangerous move, hooked jumper cables up to the backup generator, hooked jumper cables to his F-150, and literally jump-started the USA Network back on the air. And that story came to my mind so many times because that's essentially what we at Gross McGinley have been doing since March. We've been jump-starting our own business from literally a dead stop overnight. We've been working to jump-start our clients' business from a dead start overnight. And candidly, it's gone very well across the board. Now, I look at the USA Network as the perfect example because ultimately that fledgling network saved by a pickup truck is worth billions of dollars today. Will your business be worth billions of dollars? Probably not, but I think if you go through this process carefully, plan, reinvent yourself, and look for new ways to do old things, you're going to come out of this situation better than when you started. Couple seemingly unrelated topics I'm going to talk about, all dealing with contracts that all kind of tie together. The first is something called force majeure. Now, you probably heard the force majeure term bandied about a number of times beginning in March. And many of you may have never heard the term before. Force majeure is a French term. It literally means an event or effect that cannot be reasonably anticipated or controlled. And a force majeure clause in a contract excuses performance based on the occurrence of certain events. Now, to me, force majeure always sounds like something you should order in a restaurant. You get a salad and a force majeure. Force majeure clauses can be written in a variety of ways. I will tell you, it is perhaps one of the least negotiated terms in contracts, or at least it has been in the past. Some are relatively lengthy, some are very short, some go into detail, some do not. A force majeure clause in the contract is going to excuse your performance if the language in the force majeure clause applies to the situation at hand. Now, two things. First of all, when the pandemic and the forced closings first hit, everybody thought force majeure was kind of a placebo. Tom, I'm not going to pay any of my bills. I don't need to force majeure. Well, that's not entirely true. Number one, does the contract related to the bill you claim you're not going to pay have a force majeure clause? And what does the force majeure clause say? I heard the term bandied about so many times, it reminded me of the Knights of Ni in the Monty Python and the Holy Grail movie, or in the Spamalot Broadway show, where King Arthur needed passage, and the Knights of Ni would say "Ni" to hold them back. And the only way that they could gain passage is to appease the knights by giving them a shrubbery. Many of our clients thought all they had to say to their landlords, to their vendors, was force majeure, and suddenly the vendor would say, "Oh, excuse me for asking for payment. How rude of me, force majeure, let me appease you with a shrubbery." That is simply not the way a force majeure clause works. A force majeure clause is an affirmative defense. What does that mean? That means that you're saying, look, I'm in default under my contract, but I'm excused because of this condition. What does that mean in the legal world, in the world where you're before a judge? That means if the judge disagrees with you, if the judge believes that the force majeure clause does not excuse your performance, you're in breach of contract. You lose, the other side wins. So force majeure is not the placebo, and I think many people have already found that out, that they thought it would be initially. What force majeure is, if used properly, is a great way for you and the other side, whether it be your landlord, whether it be a vendor, whether it be a bank, to negotiate something that's going to make sense for the both of you, so you both can work through the current situation. And by the way, I did want to say something when I started. I'm going to say it right now. Many of you out there are small business owners. Many of you out there, I'm sure, applied for and received PPP loans. You need to understand how hard this group of people from ESSA Bank specifically, and every bank in our area generally worked to make those loans happen efficiently and effectively for you. You heard the expression banker's hours. Well, I don't think banker's hours have existed since sometime in the 70s, but these folks haven't been working banker's hours. They've been working 7 days a week, getting these loans processed, getting you your money, finding ways to keep your business afloat. So please thank your banker, whether it be ESSA or another bank, because they truly have done an incredible job for you and your business. At the end of just about every force majeure clause, you see something, it'll list a bunch of reasons why performance should be excused: wars, riots, terrorism, pandemic, epidemic, labor shortages, shutdowns, et cetera, and invariably there's a phrase at the end that says, "or other acts of God." Now, why is that there? Well, that ties into the next topic I want to talk about, which is impossibility or impracticability of performance. Paul Harvey, a great broadcaster back in the 60s and the 70s, used to always say he's going to give you the rest of the story, and I will give you the rest of the story in acts of God once we talk about impossibility, impracticability, and frustration of purpose. We've got to go back to 1861 and the Surrey Music Hall in London, England. Now, first of all, real quick fact about the Surrey Music Hall. You probably heard this statement that your First Amendment rights don't give you the right to shout fire in a crowded theater. Well, in 1856, 5 years earlier than our story today, someone shouted fire in the Surrey Music Hall during a religious service, and there was no fire, and during the ensuing melee to get out, a bunch of people were trampled to death. Very sad situation, which that bit of law has kind of moved into our American system of law. In 1861, slightly different fact pattern. A gentleman named Taylor rented the Surrey Music Hall from Caldwell, the owner of the Surrey Music Hall, for a 4-day festival. It was going to be musical performances, artisans of all sorts, tightrope walkers, magicians, a bunch of literary folks. Essentially, it was kind of a Victorian age Woodstock. if you will, 4 days of peace music and nanny narking. Nanny narking is a Victorian slang for good fun. In any event, a few days before the start of the festival, the Surrey Music Hall burned to the ground. Now, this time, fortunately, no one was in it, but the hall was destroyed. Taylor claimed he wasn't going to pay the £100 a day for the rental of the music hall because it was no longer available, therefore the festival couldn't take place. Caldwell insisted there was nothing in the contract that excused him from performance, and notwithstanding the fact that the Surrey Music Hall no longer existed, and of course, Max Yasker's farm was not available, and for those of you too young to know who Max Yasker is, he's the Bethel, New York dairy farmer who rented his farm to the Woodstock Festival for the Woodstock Music and Arts Festival in 1969. They went to court over whether Taylor had to pay Caldwell. Nothing in the contract talked about performance being excused except for the last 3 words in the contract, God's will permitting. The judge decided based on those 3 words that Taylor was excused from performance because he didn't burn down the music hall. Caldwell wasn't responsible for the music hall burning down. It was an accident. So it must have been an act of God, which is why every force majeure clause usually ends with the phrase acts of God. So impossibility, impracticability, frustration of purpose work the same way to excuse you from performance. But again, it is an affirmative defense. It is not something that you can just say and make your obligation go away. It really should be used, especially in smaller contracts, as a way to negotiate, not as an absolute bar to say I'm simply not going to pay you, because you could find yourself on the wrong end of a force majeure clause when things ultimately go to court over that issue. And I will tell you that courts do strictly construe force majeure clauses. Landlord tenant, I want to touch on real quickly. In a typical lease, a commercial lease, the landlord has all the rights. The tenant has very few rights. Very few landlord commercial leases are heavily negotiated. Even if they are, the landlord at the end normally controls the game, meaning if you don't pay your rent, the landlord is going to pursue you. And ultimately, the landlord has a number of rights, including in Pennsylvania, the right to confess judgment against you. What that means is rather than go to court and prove you owe the back rent, the landlord can simply declare you in default under the lease, enter a judgment in favor of itself and against you, and force you to go to court to prove you don't owe the money. So again, where all of this goes is it is better to be working with your landlord if in fact cash flow is an issue right now because of the shutdown and the reduction in your business, rather than simply saying I'm not paying, because ultimately not paying is likely to lead to a judgment against you that's going to result in you either needing to pay the rent, vacate the space, or both. So again, the best solution, communication, and negotiate a solution. 2 other things I want to touch on real quickly, because you're going to see these more and more. They are e-signature and incorporation of online terms and conditions. I've been looking at contracts, drafting contracts for about 35 years. One of the things I've learned is that my clients and other clients hate contracts. One of the expressions I've heard over and over again is nothing kills the momentum of a business deal like the paperwork, like it's a curse at the end of the process. In reality, it will eventually become the deal, but people see it as an impediment to the deal. Because of that, people have been working on ways to avoid written contracts, paper contracts, for a long time. P.T. Barnum is famous for the saying that an oral contract isn't worth the paper it's printed on. My corollary to that is an e-contract is far more valuable and dangerous than a paper contract. Why? Because e-contracts are still new enough that we as a society, we as individuals don't put the same weight on signing our name to an e-contract, which by the way, is as fully enforceable as a paper contract, than we do signing a paper contract. In my own experience, I have clients that would absolutely call me and say, Tom, can you review this? Who will sign an e-contract, and in many cases deny they even signed a contract. I didn't sign anything, I just clicked something online so we can move forward with the deal. Well, guess what? You signed a contract, you had intent to sign the contract, you had authority to sign the contract, the electronic signature was telling you you were signed the contract, you're bound by a contract. The other thing I'm finding with e-contracts is my clients are careless in what happens to them. A lot of people call me and say, Tom, do you have a copy of the XYZ contract? It's like, well, no, we never saw the XYZ contract. Oh, I signed that through DocuSign. I'm sure you have a copy. Well, no, unless you sent it to me, I don't. The computer didn't know I was your lawyer. The computer didn't know to send me a copy. So again, be careful with e-contracts. It is absolutely the wave of the future. Because of the issues we're dealing with now with meeting in person, being in person, you're going to see more and more companies move to e-signing. If done properly, it can be wonderful. If done improperly, it creates a myriad of issues that people have learned to protect themselves against with paper contracts that no longer, that they're not using the same level of care with e-contracts. And the last thing I want to touch on is the incorporation of electronic terms and conditions. One of the things my clients keep telling me over and over again is, Tom, isn't this nice? The contracts appear to be getting shorter. They're actually not getting shorter. They're getting longer. There's usually a provision somewhere up in the first paragraph that says, this agreement, now 3/4 of a page long, along with the online terms and conditions that are found at a website, incorporated by reference in this contract, constitute the agreement among the parties. When you sign that short 3/4 page contract, you are not only agreeing to the 3/4 of a page, you're agreeing to everything in the online terms and conditions. Very often, because the contract's short, people think no need to have my attorney review it, no need for me even read it that closely. It's a nice simple deal. They find out later they've agreed to a multitude of things: auto renewal, interest on late payments, collection fees, and a variety of other things they didn't even know were part of the deal because they never read the online terms and conditions. Please be careful with that. Please take the time to look at them. You're probably going to find they're not 1 pages or 2 pages, they're 17 pages. I've got one client that I've represented for over 20 years. The one rule they had for their main contract, their customer contract, is my portion could never be longer than 1 page. Their business got more complicated. It got harder and harder to fit everything in there until the incorporation of online terms and conditions came along. Now their contract, which is now a 1/2 page, by the way, in quote unquote paper, is 17 pages long. Nobody reads it. Nobody reads it until there's a problem, then people find they're bound by it. And then I never agreed to that. Yes, you did. Right here it is. You didn't pay on time. You need to pay us interest. You didn't pay on time. We sued you. You owe us attorney's fees. It's all in there. You just didn't know what you were signing. Again, you're going to see more and more incorporation of electronic terms and conditions as we go forward. Far more DocuSigning and other electronic contracts. Be careful. It's a changing world. It's new to many of you, something you want to be aware of. Now, I'm sure because of my youthful good looks, many of you believe that I'm the youngest equity partner at Gross McGinley. That, in fact, is not true. It is now my pleasure to introduce our newest equity partner, who is also deputy managing partner of the firm, Lauren Spezial. Lauren practices in the area of business and banking law. She also heads up our employment law group, and she's going to address some of the issues that your business needs to look at to reopen safely. Lauren?
Thank you, Tom. I assume my video is up. Just wanted to touch on a few issues that keep coming up with regards to reopening safely. You know, if you were reading the headlines, I think 2 days ago in our local press, you saw that there's been some oversight investigations. State police reported that they've issued 77 warnings for COVID-19 related violations, non-compliance to bars and restaurants. So we're starting to see some enforcement, albeit in the form of warnings at this point, not citations, but the police are around. They are patrolling. We're seeing the same thing with liquor control and making sure there's compliance. You know, I think that goes hand in hand with what we're seeing generally from the state, where we were initially with a shutdown order, and now that's been lifted as we went from red to yellow to green, and there's been more focus put on the local governments in order to police and ensure that it's businesses and its public are adhering to the various guidance and protocols that are out there with regards to minimizing the spread of COVID. So what does that mean for you as a business? What I keep telling my clients who call is it's really imperative that you remain open-minded and flexible right now with regards to your policies, your procedures, because as we've seen since March, every week brings something new, some kind of new guidance, some kind of new rule, recommendation, event that we need to think through and incorporate into our business practices in order to do what these recommendations and guidance are trying to do, which is maximize the safety and health of both our employees and the public. So what I've found is, while many businesses were aware of it, they seem to have come under the mistaken belief that the worker safety order that was put out by the Pennsylvania Department of Health back on April 15th is either no longer in effect or is merely an optional provision of guidelines with regards to how we operate. I just want to remind everyone that safety order is still in effect and should be reviewed periodically to make sure that your business is operating in accordance with what that order is stating with regards to social distancing, masking, and other health and safety measures, such as disinfecting and what to do in the event of a COVID exposure within the workplace. That is important for multiple reasons. We have the CDC guidelines. OSHA has put out its own guidelines. Department of Health has its guidelines. And for our employees, we need to be sure that we're providing them with a safe environment in order to prevent us as a business from having any type of complaint issued or reported to OSHA. The Department of Health, I was looking on that. There's a COVID complaint that can be filed with the Department of Health as well. So we're going through so much right now. To add in an investigation into your safety practices will just add a whole nother layer of complexity to what you're already dealing with in trying to open and operate and deal with the various financial and operational hurdles that we all are dealing with right now. So as part of that, my recommendation to clients is that, rather than just having, a piecemeal policy, have something in writing. It's really important to have some type of safety plan that you put in place that incorporates those recommendations from the CDC, that April 15th order, and OSHA, that you can then share with your employees so they have an understanding of what you are doing within the workplace, what your expectation is for them as they operate, and gives them the ability to address any concerns that they may have. Part of that is also having posted within your workplaces the posters that were put out by the state of the Commonwealth of Pennsylvania. It's a poster which I have referenced in my slide, which provides you with a link. I know the chamber also has a link to those posters as well. Those are supposed to be posted in your workplace, and it again provides some written guidance as to how your operations should be. It also provides a section where you are identifying your pandemic safety officer within your workplace. And that's a person that the employees can turn to if they have any questions or concerns with regards to what your practices are within your workplace and what you're doing for the public as well. So that's going to be, the safety plans, you should expect to have those in place for months to come. Once we, as long as this pandemic's going on, we're going to need to have that in place so we can make sure we're in compliance if there's any type of investigation or complaint that comes out, so you can demonstrate what you have done as an organization. Again, like I said, you have to be flexible. We are now seeing, the latest development has been the recommendation that came out July 2nd from the governor with regards to restrictions on travel and what needs to happen once persons return from various states. I believe we're now up to 17 states that are on the Pennsylvania site. And I've had many conversations with clients as to how do they deal with that, given the fact that it's a recommendation that is not directed to the businesses, but is directed to those persons who are traveling. So again, that's going to have to be considered in connection with any of your safety plans and how you're going to continue to operate. Again, being rigid in what that policy is not going to work right now. It needs to be flexible. It needs to really be real-time amendments to what is coming out and addressing those quickly as you deal with employee issues and concerns that will happen. You know, at this point, obviously happy to answer any questions that you may post now. I did want to mention just very briefly, the chamber has been doing a great job with regards to trying to get as much information out. Gross McGinley and I believe 2 or 3 other firms are participating in a free 20-minute legal consult program. I believe that Allison Pickle is overseeing in order to try to answer some of these questions that you may have as part of your continuing attempts to comply and reopen safely. So at this point, I would like to turn the presentation over to my colleague, Jason Ulrich.
A little, but my name is Jason Ulrich. I work at Gross McGinley, and I deal with a lot of the liquor license issues over here. But in light of everything that's going on, we're also going to be addressing some of the issues associated with restaurants and bars. Just to begin with, it's important that everybody know that a lot of this guidance is coming from Governor Wolf's orders, which are executive orders, not necessarily legislative orders, but we should be paying attention to the fact that as they exist are available and anybody can review them on the Pennsylvania State website. As everybody knows, we've moved into what's called the green phase for restaurants, and that has indoor dining in certain capacities. When we were initially in the yellow phase back in June 5th, we were allowed to do only outdoor dining, but that has changed. Now that we're in, there are additional restrictions on how you can operate. But in the green phase, the indoor seating is limited to 50%. Now, the way the actual order is, no more than 50% of the capacity based on the fire code, if the fire code is in existence, and in most cases in the Lehigh Valley, those are in existence, or there is another option that it can be 6 feet from another. There are restrictions on bar seating with respect to in the yellow phase, there was no permissible bar seating, but now that we are in the green phase, the restaurants are permitted to have bar seating for people as long as there's a 6-foot barrier between the customers, and that the people who are actually part of the party must be related and have come in together. So it's a common relationship is what they're looking for with respect to the physical distancing guidelines for bar service. And ironically, Tom Reilly may actually jump in on some of this because he himself actually owns a restaurant. So occasionally he likes to question me with respect to these types. With respect to the employees for the restaurants and or bars, the actual owner of the restaurant is required to provide a non-medical mask to those employees. So that's something that's important. If you are an owner or an operator of a restaurant or a bar, you want those, you're providing masks to the your employees. Now, I'm sure we've all seen the videos, issues associated with people who are coming in and are disagreeing with the mask ordinances and the mask rules. But what's important to know is that under the Governor Wolf's May 27th order, the rules with respect to wearing the masks are that customers are required to wear them when entering and exiting the restaurant or bar, and when moving around the restaurant or bar. So going to up to a salad bar if it's open at this time or something like that, any buffet service, or to a restroom, something like that, that would be considered a restaurant or bar. So the customers should be wearing the mask based on the order. It is up to the businesses, however, to enforce this essentially. So that is going to be the most difficult question that many of you business owners are going to have to address. And we're happy to help you try to get through that, as Lauren had mentioned. Now, with if we can move to the next slide, if that's okay. Pennsylvania has always been notoriously difficult with respect to the nature and service of alcohol. And in this case, I actually, on our blog, I made a joke that Pennsylvania would never actually move to cocktails to go. And in this time and age, it appears that I was made a fool of, because they actually did manage to, in Act 21, pass a cocktails to go permissibility for restaurants and bars. What everybody needs to understand about this is not a permanent cocktails to go order the way it's written. The law as written only allows for these cocktails to go in the fact that we are in a state of emergency while the governor has that declared, and that the restaurant is operating at a 60% capacity. Now, as Lauren mentioned in her presentation, there are PLCB agents out there reviewing this, and the difficult issue is trying to figure out what exactly the 60% is and when this mitigation period will terminate. We don't know that yet, and that's why we actually recommend that you contact an attorney to discuss this if you're worried about the issue, because it is we don't want you running afoul of something that could potentially cost you a liquor license if you're dealing with it. But beyond that, it's difficult to determine when exactly this mitigation period is going to end. So if we move forward with cocktails to go, if you're doing that for your business, please contact an attorney to review that issue to make sure you're not potentially endangering your own liquor license. Some of the other important things to point out are these cocktails to go can only be sold before 11 p.m. And this is the somewhat a more important one. The containers actually have to be sealed and placed in a trunk or an area that is not driver occupied. Now, this was put into law in order to avoid the potential issues associated with drunk driving, DUIs under Title 18. And what most restaurants and bars that I've been working with have been doing is they've literally just been putting them in the trunk because it's the safest way to do it. The restaurant doesn't want to run into any dram shop liability, or the restaurant and bar doesn't want to run into that. And overall, the safest thing for you to do if you're a business owner who has a liquor license is doing cocktails to go is to put them in the trunk. It's something that you do not want to, put your license in jeopardy over. There was also a provision under Act 21 that the automatic scanning of IDs has to be implemented within 60 days. So the deadline will be coming up shortly on that. So that's one of the things that you're absolutely going to want to be careful about. Many of the restaurant owners and bar owners do not have the automatic scanners yet. So you will want to invest in that if you are continuing to do cocktails to go, because that could potentially be an issue associated with your license, and you don't want to, again, run into that. So, and finally, just to make sure that everybody's aware with respect to the last portion of the cocktails to go, it is actually cocktails to go. It's not drinks to go. So you can't just put a glass of scotch in a cup and put some ice in it. You actually have to make mixed beverages, and they have to be between 4 ounces and 64 fluid ounces per transaction. It's similar to the 128 ounces of malt alcohol that can be sold, that you have to make sure that it is below that particular deadline, so that person can go out and come back in, but they cannot, do that as a singular transaction. So beyond that, that is all I have with respect to the restaurant and liquor license issues. And if anyone has any questions, I'm happy to answer them.
Well, thank you so much for this great presentation. I think it was really informative. I know it was a great refresher, but a lot of new information. So thank you to all our presenters, and my apologies, my my video won't pop back up, but that's okay. We'll keep moving on here. We did get some questions, some of which were already answered through the presentation, but we do want to thank all our panelists for joining us. Barry Reifinger, Jim Ferry, Aaron Petulowicz from ESSA Bank and Trust, Tom Reilly, Esquire, Lawrence Baziel, Esquire, and Jason Ulrich, Esquire from Gross McGinley. This was really a fabulous presentation. I really thank you for presenting and for sponsoring. And we did record it, as I mentioned early on, so we will have this up on the Chamber's website, and we will also send you the presentation if you, so that you can see it, and maybe that will prompt other questions and we can happily get you other answers. We are perfect timing wise, so I am going to offer you a great day, and thank you so much for joining us, and thank you to our wonderful and talented panelists. Have a wonderful day, everyone.